Williams would flee the jurisdiction of the court. What that means is he would not come back to court.
No, he more definitely come to court.
Do you know if Mr. Williams has family in this area?
And what you mean, Atlanta?
Yes.
I know his whole family. Yeah, so he's never leaving his family.
His whole family's here?
Yeah, I know his whole family.
Same on your oath, any evidence or any belief, any speculation that if granted bond, Mr. Williams would obstruct justice?
No, he wouldn't obstruct
bribe
justice.
a juror?
No, never.
Intimidate a witness?
Never.
If granted bond, do you have any evidence that Mr. Williams would be a risk to commit a crime while out on bond?
Never.
And if granted bond, do you have any evidence that Mr. Williams would be a danger to any person in the community or any property in the community?
Never. He's a motivator to our community. So I can't see him hurting nobody.
When you say a motivator, does Mr. Williams actually talk to people in the community about being lawful?
All the time. We can get, if y'all want, we can bring hundreds of people in here from the community and they can tell you one by one, he motivate them. Like, if you got I got a buddy who cut grass. If you cut grass, he'll buy more equipment to cut grass. Like, this is what you want to do? Okay, do it, and do it 100%. You got to think. He stayed down with music, and we seen him go to the top and say the same thing. Stay down. You can have 3-4 lawnmowers. You can be hiring people. Like, that's how I look at him. I know, and a lot of people look at him like that, as a motivator. If they didn't, we wouldn't be in here supporting him.
I want to thank you so much. The prosecution, this honorable court may have questions for you.
Okay.
You?
No questions, Judge.
You all right?
Mr. Mitchell, thank you very much. You can stand down.
Okay, have a nice day, Judge.
Have a seat, McGovern. Thank you. Welcome.
Your Honor, we will call, thank you so much, Mr. Corey Jackson.
What's Mr. Jackson going to testify to?
Your Honor, he is a young man.
How many witnesses do you have, Mr.
Kevin Liles, Kevin Liles.
Good afternoon, sir.
How you doing, Mr. Steele?
I'll let you know. Can you do me a favor and give this honorable court, educate this honorable court on who you are, your background? The court may not be familiar.
Your Honor, I'm a 54-year-old father of 4. I'm kind of emotional because how good this guy is. I have Morgan State University. I built a stadium in my old school. I have a street named after me. I have all kinds of honorary doctorates. I employ probably 5,000 people. I was the president and the CEO of Def Jam. I've been in this music called hip hop for 38 years. And for the life of me, I don't understand why I have to testify the good that hip hop has done around the world. I've also started a company with Jeffrey called Young Stoner Life. And I remember what he said to me: we're not just starting a company, we're gonna change some lives. And that's what he's done. And he's definitely changed mine.
Mr. Liles, how long have you known Mr. Williams?
I was a fan for probably 12 years, but I personally got to know him over the last 10 years.
Okay. And have you signed, or your company signed Mr. Williams?
Yes, he signed to us. I hate saying that he signed to us because it's my partner, but we have 2 deals. One deal is a deal for him as an artist, solo artist, and the other deal is for Young Stoner Life.
And I know this is personal, but financially, there's been testimony that if this trial, and I'm not saying the court will allow it, but if it doesn't take place for a year, there'd be over $1 million in expenses just for 24-hour security of police officers to ensure, off-duty police officers' second jobs to ensure Mr. Williams does not flee, does not get types of weapons, non-intimidating witness, it's not a danger to community or property in the community. Can you afford, from your personal knowledge and how much money he earns, can you afford that type of undertaking?
Jeffrey can afford it, and I can afford it, so it will be paid for.
And you were willing to back him as well?
I'm willing to back him personally and professionally.
Please explain, if you can, and discuss fully how your life intersected with Mr. Williams' life.
My job is to seek out talented people. And I think God brought us together in a very weird way, but I think we were meant to be together. Jeffrey is not just an artist. He's an influencer. He's a person that I think was put here to change the people around him. And he's so talented. He's creative, he's innovative, and he's fearless. He's a risk taker. And those kind of people, I call them change agents. I'm not signing this artist, I'm raising a young man. He looks at me as a father figure. He's not, like I said, we can't limit it to just his lyrics or his music. He's a young man, he'll be a contributing citizen to this world, and that's what I invest in. And I truly believe this whole thing that people are talking about, it's not him. The Jeffrey I know give me clothes off his back. The Jeffrey I know, I give him my kids, he give me his kids. That's the Jeffrey I know.
You mentioned lyrics. There's been a lot of argument by the prosecution about the lyrics in the songs. Can you explain, if you have it in sight, what is selling in the rap industry dealing with the lyrics, and why are they being promoted, and why are people wanting it?
Your Honor, you've I don't know how old you are, but you know older than you. So I've been fighting this battle for over 40 years. It's not new. And it's funny how we're the #1 music in the world now, and they want to bring this back up. Now, we don't argue about any other movies or other genres of music that talk about I ran them over in my truck, or I got drunk and I went and shot them. We don't bring those things to court. But quote unquote, our music, we've been on trial. And we constantly on trial about who we are, what we are, and why we're. And nobody gave us nothing. So we sit here on trial, we talk about lyrics. Lyrics. I don't understand the thing. I would be here and I'm gonna keep fighting for it because I believe self-expression. And I believe we should protect Black art. We should protect Black art. And I'm on trial for lyrics. Come on, man.
With regards to Mr. Williams, and the court may not be familiar, where does he rank in, if there is such a ranking, in the music industry?
Objection, Judge, that's not relevant to anything.
It shows his employment status as part of the Ayala factors and whether the record company is going to continue to back him.
I think you've already established that to the witness, so it's what it means to potentiate.
Kevin Liles in there speaking it, man. Kevin Liles in there dropping jewels.
You understand?
He in there defending the culture.
Williams was charged in 2018 in DeKalb County with a offense involving, he was riding in a car with 2 other people, and there was a gun and a small amount of drugs in the car. Are you familiar with what I'm talking about?
Yes.
Okay, and you know that case is still pending, believe it or not, but it went up to the appellate court. I don't know, are you familiar with all that?
Yes.
Everything was suppressed by the Honorable Superior Court judge in another county, and then the state appeal got reversed and it's pending. You're aware of that?
Yes.
Okay. So Mr. Williams is actually on bond for that case.
Okay.
The allegation also entails the fact that when Mr. Williams was arrested at the home here in Atlanta, a search warrant was then executed at that home, and there were multiple firearms. One firearm is allegedly illegal. It turned into like a machine gun. And there was supposedly about 2 pounds of marijuana and some items in, looks like an energy drink, but it supposedly contains either Schedule 2, 3, or 4 drugs in it, codeine, supposedly. You're familiar with that?
I read it.
Okay. Understanding all those facts, the DeKalb County case, current bond, and the search of the home, you're also aware that many other people were in that house at the time of the search warrant, right?
Yes.
Okay. I'd like to ask you the following questions in addition to the fact that we are charging 2 counts in this current indictment. You're familiar with the RICO conspiracy and the gang
Yes.
count? Okay. On your oath, would you be willing to back with your own personal property and wealth, as well as your own company's personal property and wealth, the bond for Mr. Williams, if the Salvo Court wanted a high bond?
Judge, she's asking us, he's already, the witness actually is already stated that, and I was pretty.
Yeah, he already said
I very clearly heard that.
he put up his own and his company's resources, so it's outstanding, Judge.
Would you be willing, okay, if it's the same question as, I apologize, but I thought it's a different question. You have to understand that you would, if the court wanted to, you would lose that wealth if Mr. Williams violated condition of bond. I mean, it's not just go on bond when Mr. Williams in custody, you're released. The court could have you sign as a co-signer on that bond, and you would actually have a lien against your wealth if Mr. Williams violated condition of bond. Are you still willing to do that?
I could certainly be. Yes.
Okay. Without hesitation.
Without hesitation.
All right. Do you believe that if granted bond on your oath, Mr. Williams would intimidate any witness?
Nah.
Obstruct the administration of justice?
No.
Be a danger to the community or property in the community?
Not at all.
And a risk to commit a crime while out on bond?
No, not at all. He has too much respect for me and too much respect for the company that we're building and too many people that depend on him. It's not about Jeffrey. It's why it's about the family. It's about the community. You know, he understands. He's inspiring the world right now. There's a kid that he changes their life every day. I really believe that.
For the better?
For the better.
I have one last question for you. If this honorable court granted bond, but it was very, very restricted. Mr. Williams is not coming out to studios. He's not doing videos. Speaking with him may be curtailed. Is your record label still willing to keep him as a vibrant member of SIM?
That's my partner.
And just for the court's edification, I think you just said, but Mr. Williams is not only an artist, he's the owner of the company, right?
He's a businessman. I told him hip hop has given him a way to be an entrepreneur, a way to empower people, a way to educate people, and he has a responsibility. He knows that with this success comes responsibility, and we made a commitment to each other that we're going to do this for the rest of our life.
I want to thank you so much.
Thank you, Your Honor.
Hold on one second. Any questions? Okay, all right. Then I'll release this. Thank you very much, Mr. Jackson. Mr. Liles, I should say.
Some of the evidence that's been presented in the other cases and or proffers, we intend to, again, proffer in this case as well. Hearsay is admissible, and we intend to go in that direction. And Judge, I'm going to say something here in a minute, and it's not my intent, please, to offend the court. I'm going to go somewhere with this, so please bear with me in a second. This is all about money. This is an attempt to say, Judge, I can buy a bond, respect to the court. Judge, everything you heard was someone that has a financial interest or some other professional interest relying on Mr. Williams. Yes, they need him out. Yes, they need him to be there. Yes, it's very important to them because it's all about the money. Mr. Williams has said in his songs, it's all about the money. And there's no difference. That's exactly what it was today. It was, I've got money. I can pay for whatever you want me to. But here's the problem, and I'll get to the specifics in a second. Every other defendant that's had a bond motion, we've shown they're a danger. And there's no issue about, well, what can, okay, can you pay for this or pay for that? But they don't meet the Ayala factor. Okay? They want you to just get by, Judge, by the Ayala factor and say, here's what's more important. We can pay for all this. But their logic falls on themselves. The investigator that came up very nicely stated, jails are corrupt, they can get stuff in there, and he shouldn't be in there for that reason. What officers are they going to hire? How do we know, because there's no supervision if he hires those same officers he's speaking about in jail or on the road to be those 24 officers? Now we have even less supervision and less ability to ensure the safety of the community. So again, it's about the money and what can I do to pay my way out of jail. I will say there's a Act 9 on 4/2014. It is a song. The name is EWW, and in it, basically, the defendant says, all I ever wanted was the money. Basically, if you mess with me, you go into a wheelchair. That's what that one says. Your Honor, we have other, and I'll leave some of the social media, I'll handle that generically for the most part, but we have numerous social media posts where the defendant is in what I would call gang colors, flashing gang signs with his fellow gang members, some of which are his co-defendants on this indictment. And on those, they are, on the videos, they are replete with gang statements, gang hand signs, threats, etc. Judge, and again, they're listed in the indictment. Judge, the murder of Donovan Thomas that we've spoken of a few times, that's basically Act 16, 17, 18, 19, and 20. In that series of acts, in Act 16, the state can prove that, or I will say this, it's the state's contention that the car used in that murder was a car rented personally by Mr. Williams just days before. And evidence will come in concerning the beef between Mr. Williams and Mr. Donovan Thomas that involves another well-known rapper and how that gentleman's career was going to go. And Mr. Thomas and Mr. Williams had a serious disagreement about that, which led to Mr. Thomas's untimely death. Your Honor, on Act 25 from January 25th, 15, we have a conversation. The conversation is an electronic digital form where the defendant states sacrifices must be made, soldiers must fall in order for battle to be won. And then it goes on to talk about everyone has to line up between all the sex, money, murder, which is a subset of blood, which basically YSL comes under, that they must all line up under one of 5 leaders, and they must do so immediately. And that is again from Mr. Williams. Your Honor, on 126.
Is that in a, you said that's in a digital?
It's in a digital format, yes, Judge.
Is it a conversation? Tell me the context.
Yes, Judge.
Okay. It's a conversation?
It is, I believe it's in the form of a group chat where Mr. Williams is putting this out to many, but to his crew.
And when did this occur?
This occurred on 125/15, Judge.
Okay.
Okay, now the next day, 126/15, remember, now let me take you back again already. On 110/15 was the murder of Donovan Thomas here in Atlanta, Fulton County. Okay, so approximately 16 days later, Mr. Williams releases a video. And he's basically stating, or doesn't basically say, I should be quoting, is that he basically says, if anybody goes into a courtroom and tells the God's honest truth, and pardon my language, they need to get fucking killed. And again, that's only 16 days after the murder of Donovan Thomas.
Counsel for the state as well as for the defense, I'm sure aware of. I'm looking at Coleman versus the state, and that's already been cited. That's 361 Georgia Appeals 901. And I'll quote from that decision, which comes from our Court of Appeals, Judge Miller, the presiding judge in that particular case. Excessive bail is prohibited by the Georgia Constitution, Article 1, Section 1, Paragraph 17, and the 8th Amendment to the United States Constitution. And for the 8th Amendment analysis, as you all are aware, that 8th Amendment violation would be excessive bail or no bail, or fixing an amount that is excessive under the circumstances. When fixing, for the purposes of the 8th Amendment, the excessive bail is defined as bail set at an amount higher than the amount reasonably calculated to ensure the presence of the defendant. When fixing bail in Georgia, trial judge's foremost consideration is the probability the accused, if free, will appear at trial, and then the court in Coleman goes on to quote that lesser factors or lesser extent or considerations are the accused's ability to pay, the seriousness of the offense, the accused's character and reputation. I've heard a lot of evidence today about those particular factors in regards to Mr. Williams and his ability to pay, and the seriousness of the offenses, and his character and reputation from presented by Mr. Steele, Ms. Hornsby, as well as Mr. Adams. So I have considered those particular issues. Now, also, Coleman goes on to say that a defendant who seeks release on bail has the burden of showing roots in the community. The defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating witnesses. And along with this particular case, the court also has considered the seminal case of Ayala versus the state at 262 Georgia 704. And Ayala gives us the framework in Georgia.
He ain't finna get no bond.
The purpose of a pretrial bond is to prevent punishment before conviction and secure the appearance of a person for trial, quoting Roberts versus the state, 32 Georgia Appeals 339. And it goes on to say that a trial court may release a person on bail if the court finds the following. So I have to look at the first thing that Coleman directs me to look at is consideration of whether or not the foremost consideration is will he, if freed, appear at trial, and then the lesser factors, and these are a court may release a person on bail if the court finds 1, poses no significant risk of fleeing from the jurisdiction or failing to appear in the court when required. 2, poses no significant threat or danger to any person, to the community, or property in the community. 3, poses no significant risk of committing any felony pending trial, and poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And I'm required to explain any reasons if I deny bond to assist the appellate court in this review, and that the granting or denial of bond will not be set aside unless there's a manifest and flagrant abuse of discretion. That's Jernigan versus the state, 111 Georgia 307, pinpoint 308, very old case from 1903. Now, in regards to considering bond for Mr. Williams, I have considered, the first consideration is if free, will he appear at trial, and to a lesser extent, the other factors. And based upon the court's consideration of the proffer, the two things that the court has significant concerns about are him being a danger to the community and flight. And I'll state for the purposes of the record and for purposes of my decision that I realize that Mr. Williams is presumed innocent. I realize that he has the presumption of innocence stays with him until the state, by sufficient evidence, is able to prove to a jury's satisfaction beyond reasonable doubt, I should say, that he is guilty of the offense or offenses charged. But however, in this particular circumstance, there have been significant proffers about Mr. Williams as being a danger to the community. In particular, the state's proffer that they have taken proffers from other gang members and people who are in this particular indictment and they're not in this indictment, that he is the leader of the gang.
Yeah, that's some motherfuckers telling.
Dangerous, and if he crosses them, he'll kill them or their families. And the predicate or the review of the state, the concerns that I have are some of the statements that he's made about the threats and to others, and that have been chronicled in particular in some of the predicate acts that have been stated for the court's consideration. Whether or not those acts, as Mr. Adams has pointed out, because they have to be proven at trial, is a discussion for another day. But at this point in time, in the aggregate, those particular discussions, in particular, the proffer from the people that the state has talked to already, the group chat that from 2015 starting, anybody goes into a courtroom and tells the honest truth, they'll be fucking killed, pardon me for the language, and this threat is still being talked about. So that is of a concern to the court in regards to the danger to or threats to persons in the community. So and factors there's no significant arrest of intimidating witnesses or otherwise obstructing the administration of justice. That is the court's concern. The two major concerns that this court has is danger to persons and threats to intimidate other witnesses and obstruct the administration of justice. So I have some concerns about the flight that I share with Judge Wolf also indicated, but and I'm not going to hold it against him that he is very successful and has significant means, but those two factors in particular, threats to persons in the community or pose a significant risk of intimidation of witnesses and otherwise obstructing administration of justice, the court has considered a number of the predicate statements, and for those reasons in the aggregate, I'm going to deny bond at this time. But Mr. Adams, Ms. Hornsby, and Mr. Steele, certainly if we should file any other additional motions or things change, I certainly will reconsider the court's position on bond. It is not lost on me that I have not given your client a bond, but that is my decision based upon what I have heard, and I certainly appreciate your advocacy on behalf of your client and all of the lawyers thus far who have advocated very well for their clients in this particular position, and I will do my level best to make sure that this case gets tried as expeditiously as possible, and if I can get it on the calendar before the 9th of January, I will endeavor to do so. So, anything else at this point in time?
Okay, Judge.
Yes.